Whenever patents come up in gaming, people usually react with the same question. Why can gameplay mechanics even be patented? Whether it's Nintendo, the Nemesis System, or some bizarre patented mechanic, the general feeling is that these patents do more harm than good. As a paralegal with experience in IP law and litigation, I will explain why gameplay mechanics can be patented, how those patents are used in practice, and the issues they have raised in the industry. But before we dive deeper into this, let's just quickly define what a patent is. Generally speaking, patents are an exclusive legal right granted for 20 years for an invention. They give the owner the right to stop others from making, using, selling, or importing the patented invention without permission. Under the European Patent Convention, an invention must be new, involve an inventive step, and be susceptible of industrial application. UK patent law uses almost identical criteria, whilst the US uses a very similar framework. For the purposes of this video, I will use all three models interchangeably throughout my reasoning and analysis. But I will note that the patents we will be looking at are mainly ones covered in the US. Okay, so what are the issues with gameplay mechanics being patented? The first issue we need to consider involves patents being used as legal weapons. To do this, we need to explore a story that may already be on your radar. In September 2025, a huge patent scandal emerged from Nintendo's camp, when they managed to successfully file a patent in the US in relation to the game mechanic of throwing an object to summon a sub-character to support the main character in battle. Yeah, a lot of words. In simpler terms, Nintendo was specifically attempted to patent the gameplay mechanic of summoning a character from an object, like their famous Pokeball. And as a recent update, a re-evaluation by the US Patent and Trademark Office revoked that patent due to prior art being discovered. However, this case study still provides a clear overview on how patents can be weaponized. One of the major problems this patent raised was its vague interpretation, because the patent loosely captured the gameplay mechanic of summoning any character. If you've ever read a patent, you can immediately see how vague and abstract they are, and even I struggle to read them on face value. Patents are drafted in this way to mainly ensure that competitors avoid escaping infringement by changing minor details of the patent. It is an extremely technical form of language used to ensure robust legal protection. The problem with that vagueness is it captured a wider area of the gameplay mechanic, which is what has caused a worry amongst the game community, and the fear was understandable. A patent framed around summoning a sub-character to fight covers a wide area of games which involve deploying allies, companions, creatures, or support into combat, leading to many fearing that such a patent would be weaponized on the industry for such a basic gameplay mechanic. Now, to be fair, this kind of weaponization is rarer in practice than people sometimes suggest. Nintendo holds thousands of patents, and if it wanted to wage war on the whole industry, it could try, but that would be mutually destructive. Other major publishers also hold patents, and broad retaliation would turn into a legal arms race that nobody really wins. So when gaming media treats every controversial patent as the death of game design, I think that usually overstates the situation. But that does not mean the concern is overblown. The issue is not that Nintendo will sue everyone. The real issue is that a patent only has to be deployed against one serious rival for it to become a competitive weapon. And that's exactly what happened to Palworld. Palworld is a game that has gained a huge cult following over the years. It gained huge popularity during its reveals and early access phase because it provided for many players an innovative Pokemon-like style experience that fans have always wanted. That similarity though was a huge threat to Pokemon IP and Nintendo. That's why when Palworld was announced, Nintendo acted quickly and attempted to lock down their throw item to summon and throw item to capture loop, a distinctive gameplay mechanic of the Pokemon games that was now also found in Palworld. They immediately had the patent filed in Japan, and with that protection they also filed a lawsuit against Pocket Pair. The US filing that I mentioned that was rejected was their attempt to also bring proceedings or the threat of in the US, which is also gaming's biggest market. The timing of this scenario tells us a lot about the weaponization of patents. I find it incredibly interesting that the patent application came along just after Palworld was revealed. Nintendo only moved to enforce these gameplay-related patents once Palworld had emerged as a credible rival. They became strategically important only when another studio proved it could compete in the same space. If a dominant company can assert broad patents over familiar gameplay loops once a rival proves success, then patent law is not just protecting invention, it is raising the legal risk of competing in the same space. And the reason patents are so effective as a legal weapon is because patents unlock litigation pressure, a tool that can either force developers to change features in their games, as we see in the case of Palworld, who although still protecting themselves from Nintendo's claims, changed elements of the gameplay that could be deemed to have infringed Nintendo's patents. For example, they removed the ability to throw their Power Spheres to summon creatures. Instead, they now spawn from the player's side. That pressure becomes even more powerful when you factor in cost. Patent litigation is expensive, slow, and risky. A large rights holder does not always need to win outright. sometimes it only needs to make infringement risky enough that smaller developers choose not to fight or decide not to enter that design space at all. In a sense, the threat of litigation is more effective than the patent itself, as it unlocks the potential to litigate on your IP in ways that other legal protection can't. More on that later on in this video. Overall, this shows that patents can be used as a tool to pressure on competitors. But patents could do more than just be used as legal weapons, as next we will see that they can also gatekeep incredible innovations. When anyone ever talks about video game patents, they always mention the Nemesis System. The gameplay mechanic introduced in Middle-earth: Shadow of Mordor is arguably one of the most original gameplay systems of the last decade. It created dynamic enemies with their own traits, rivalries, memories, and evolving relationships with the player, meaning that each playthrough could produce its own personal stories. Such a feature gave an absolute unique experience to every player's playthrough. As you may already be aware, this is an incredible gameplay system that has been patented by Warner Bros. Games. I want to explore this as a case study on how patents can prevent innovation due to their ability to gatekeep inventions. When a patent is issued to an inventor, they hold the right to that patent for 20 years. This means, of course, only they can benefit from that patent exclusively. In this case, the Nemesis System is only found in the Middle-earth games, essentially being gatekept from the entire gaming industry. There are many games that would have benefited from this system that sadly just can't until this patent expires in 2036. That exclusivity might be easier to defend if Warner Bros. Had gone on to actively build on the system, refine it, and push it into new games. But that is exactly what makes this case so frustrating. Outside the two Middle-earth games, the Nemesis System never really became a wider concept. And then in 2025, Warner Bros. Shut down Monolith Productions altogether and cancelled the Wonder Woman game, which had long been reported as the studio's next major product to include this system. Now we are left in this bizarre situation. One of gaming's most interesting patented systems has barely been used, and the studio that created it is now gone. So why are patents designed this way? Well, patents are like this by design to protect the inventor of a creation and allow them to recoup their investments. The classic example is pharmaceuticals. If a company spends years developing a new drug, then there has to be some reward for being first. This is the bargain patent law tries to strike. In exchange for disclosing how the invention works, the inventor gets a limited monopoly, and once that period ends, the public is free to build on it. Now, in theory, this is all great, but the problem is the timescale. Patent protection is built around a much slower model of innovation than what software and games are actually operating on. In games, technology, trends, genres, and even hardware generations move far too quickly. 20 years is not just a long time. In software terms, it's often an entire era. By the time a gameplay patent expires, the problem it once addressed may already be irrelevant. A good example of this is Namco's old loading screen patent. Namco filed it in 1995 and secured protection over minigames played while the main game loaded. At the time, especially in the PlayStation era, that was a clever and innovative solution. Long loading times were a real technical problem, and the patent let Namco keep that feature largely to itself for around 20 years. But by the time the patent expired in November 2015, the industry had already changed. Faster hardware, better optimization, and eventually SSDs had made the traditional loading screen far less important than it had once been, so the wider public did not really get the benefit that patent theory promises. Namco got the exclusivity, but by the time everyone else was free to use the idea, the moment had largely passed. That is exactly why the Nemesis case feels so wasteful. If the point of patents is that society eventually benefits from the invention after the exclusivity period ends, then what happens when the invention is locked away during the years when it would have mattered most? In that scenario, the public does not really gain much at all. The industry misses the most creative and commercially relevant window for building on the idea. Had the Nemesis system been worked on all these years between many developers, we could have innovated the system even further. Because although the system found in Middle-earth are great, its potential is massive. Imagine a Batman or pirate game that featured the Nemesis system. It honestly would have likely spawned a subgenre of new games built solely around this system. And this is why I think game patents deserve a different level of scrutiny from patents in other industries. You can't really compare patented gameplay mechanic to a life-saving drug or a major engineering breakthrough. I'm not saying there is no investment involved in creating a system like Nemesis. Clearly there is, and the inventors should benefit from it, even if they do nothing with that invention. But fast-moving industries should maybe have a reduced period of exclusivity to allow incredible inventions from being barriered until its true impact has been missed. However, the reason a version of the Nemesis system isn't seen today isn't totally because of the patent. This is where there is a slight gap in knowledge of patents from the industry. Although patents are written vaguely, as I mentioned before, they still have to be extremely specific to satisfy being an inventive step. This applies to gameplay mechanics as well. The overall idea of the Nemesis system is not patented. How that system operates is. This is what took Warner Bros. 6 years to establish to finally have their patent granted in 2021. And if you read the Nemesis patent, it is detailed and technical, which is part of why it took years to get granted. A similar system is likely possible with enough variation. This is illegal advice, but I believe developers can create something more innovative and something that won't infringe on that pattern, especially with a great legal team on their side. You can already see signs of studios playing around at the edges of that idea. Assassin's Creed Odyssey had a mercenary system where named mercenaries had identities, strengths, weaknesses, and persistent tracking. Warframe introduced the Kuva Lich system in 2019, building its own long-term rival structure around recurring enemies. So clearly the broad design space is not completely closed. But what we haven't really seen is the kind of full industry-wide experimentation that might have happened if the most famous version of this mechanic had not sat behind a pattern for the years when it was most exciting. Now, if you enjoyed this video so far, why not hit that like button and sub below? Okay, let's move on to the next issue. A big issue with patents in the games industry is how far publishers are willing to push them. Once you start looking through video game patents, you quickly realize that companies are not just trying to protect major technical breakthroughs. They are often trying to lock down features that feel incredibly narrow, oddly specific, or just plain excessive. One example is Mass Effect's communication wheel. The wheel itself is not patented, as you've probably seen many other games with this feature. The patent was about a graphical interface for interactive dialogue and the segments within the wheel itself. Why they needed this patent, who knows? But this shows how wacky these patents can get and makes you seriously question what the point even is. Why do developers and publishers choose to patent gameplay mechanics? And the answer in simple terms is because there is no other clean legal right that protects gameplay itself. People often assume copyright protects anything being copied, which includes gameplay mechanics, but that is not actually true. Copyright protects the expression of a work, the art, the music, the code, the writing, the visual design, not the underlying idea or mechanic of a game. Trademarks do not help either, because trademarks protect branding such as names, logos, and slogans. So if a developer wants legal control over a gameplay mechanic, patents are often the only serious option left. As a legal professional, and again this is illegal advice, I will tell you now that every lawyer in this entire world will tell their video game developer clients to patent their unique gameplay mechanics, especially if they wish to prevent copying. And this is why every single major developer has thousands of patents. I wanted to raise this point as well, as we often see the narrative being portrayed that any developer that attempts to patent a gameplay mechanic is doing so for the greater evil. This isn't the case, and this next case study provides a better overview of this.
Hey, come on over, have some fun with Crazy Taxi!
Sega patented the arrow navigation system in Crazy Taxi. The patent covered a game display method involving directional indicators towards a destination in a driving game, among other features. Essentially, they had a patent for nearly every mechanic in the game, which together made the formula for Crazy Taxi. And again, it's one of those examples where you look at it and think, really? This got patented? Well, these exact patterns were used to file a lawsuit against Simpsons Road Rage for their game, and they're used for a very similar Crazy Taxi formula. The reason Sega went after Road Rage was simple. In legal terms, it was because they had infringed on their patents, but unofficially, it's because they had copied their entire gameplay. Road Rage is essentially Simpsons' parody of a Crazy Taxi game, quite near a one-to-one copy. This would of course have hurt Sega with how successful the game was, and so they used the patent as a tool to protect their work and get compensated for the idea. A patent for such a simple system was the only tool available for protecting an entire game, brand, and company. This should hopefully make you realize that these patents can feel ridiculous, oddly specific, and harmful to creativity. But on the other hand, without patents, developers often have very limited protection when another company comes along and copies their entire game. The law leaves gameplay in an awkward middle ground. It's too important to ignore, but too abstract to protect neatly. And patents, for better or worse, have become the industry's answer to that problem. So far, I've tried to provide an overview of some of the bigger cases and issues dominating the patent debate. What I want to do now is really consider how effective patents even are in the video game context. I believe by exploring patent trolls, we can reach an answer to this. If you didn't know what a patent troll was, they basically seek revenue by asserting patents against alleged infringers rather than primarily making products based on those patents. Worlds Incorporated is an example of a supposed patent troll. Worlds held patents filed in the 90s that related to systems and methods for enabling users to interact in a 3D virtual space. This patent was interpreted to cover the ability to see other players' avatars, their movements, and their facing directions in real time, especially in multiplayer games. Through this patent, they were able to use it broadly or aggressively to pressure developers into settlements or licensing deals simply because litigation is expensive. Well, Activision had enough of this, and I assume just refused to acknowledge the patent outright. Therefore, in March 2012, Worlds sued Activision Blizzard, alleging that games including World of Warcraft and Call of Duty infringed several of those patents. In April 2021, the court ruled against Worlds, saying its patents were too abstract and didn't contain any real inventive step. This case is a strong example of how these patents can function more effectively as legal pressure rather than an actual legal barrier. The lawsuit lasted about 9 years before the 2021 ruling. which helps explain why the threat itself can matter so much, especially to smaller developers who do not have Activision's resources to continue fighting on these illegal battles. But it does give hope that a gameplay pattern does not give you ownership of a vague idea. In practice, the fight is over the claims, because the claims define the legal boundary of the pattern. That makes gameplay patterns awkward to enforce, because a rival can often change the implementation, sequence, or technical framing just enough to argue that it falls outside the claim. So in court, a patent holder usually has to do two things at once: prove that the rival copied what is actually claimed, and prove that the patent was valid in the first place. This is why patents are so difficult to enforce. They can't just prove that the game copied broadly and infringed on that patent. They have to go through each specific claim and prove that pattern was infringed, exactly one-to-one in the other game. What this suggests to me, and again, this is not legal advice, sorry for hearing that 100 times, is that developers may need to be more willing to challenge these patents in the way Palworld is now forced to. If a company claims it owns a patented mechanic, then that claim should be tested in court rather than accepted at face value. Because just as some rights holders use the fear of infringement as a weapon, exposing the actual weaknesses of a patent through legal scrutiny may be enough to discourage aggressive threats in the first place. And that just may be the answer to stop all of this fear-mongering around patents. Gameplay mechanics can be patented because patent law does not look at them as simple ideas in the ways players do. It looks at them as claimed processes, systems, or computer-implemented methods. And once a mechanic is broken down into specific technical steps, it can start to look patentable on paper. In other words, developers are usually not patenting press a button to do X in the abstract. They are patenting a very specific particular way that system is implemented. And that is really the heart of the issue. Gameplay patterns are possible because the law treats them through technical claim language, rather through the common sense way players experience them. Sometimes that is fair, sometimes it protects generally clever systems. But as this video has shown, it can also let vague, overreaching, or underused patterns distort competition, gatekeep innovation, and create legal pressure far beyond what the underlying mechanic really deserves. So no, gameplay mechanics are not the end of gaming. Most are narrower and weaker than the headlines make them sound, but they are still powerful enough to shape behavior through cost, fear, and uncertainty. Hopefully developers and publishers can realize that collaboration and sharing ideas is what grew this industry in the first place. But until then, patterns will remain in the industry whether we like them or not. That brings us to the end of the video. As always, a like and a sub would be greatly appreciated. Let me know your thoughts in the comments. If you want to know why some games can copy, then this video on the left is for you. Alternatively, if you never knew that mods are actually illegal, then this video on the right is for you. Take care.